Recording in progress.
Good morning, members. Good morning, all. Good morning to the representatives of the Department of Justice and Constitutional Development. Good morning to the Constitutional and Legal Services of Parliament. Members, welcome back after a long period of separation. We are just from the long constituency period, which was later followed by the members' leave period, which ended Friday last week. We hope that you have rested, you have been able to connect with communities during the constituency period. You have been able to go to church. To those who believe in churching, we are back now for the last run until June. Just a small point, members, that you will recall that this period would have ordinarily been a period of annual performance plans, strategic plannings, and budget. But I think we all know the budget fracas that Parliament has been engulfed with, which has led to the budget arrangement being taken for a reworking, which will be delivered on the 21st of May, 2025. So due to those circumstances, we have been compelled to rather postpone all the APP process, strategic planning and budget. So we're going to rework the committee program to ensure that immediately after Parliament agrees on budget, we therefore take to consideration those APPs and strategic plannings and budget. Members, today we're dealing with only two legislative items. The first is the Judicial Matters Amendment Bill. The second is the legal opinion from the Constitutional and Legal Services of Parliament on the State Information Bill. We'll start with the presentation from the Department of Justice and Constitutional Development. Committee Secretary, can you confirm if the department is in attendance?
Good morning, Chair. The department is in attendance. I think I also saw the minister online.
Thank you very much. Minister, can you lead your delegation? You will tell us who then will do the text presentation as you'll be introducing the presentation of the department. Over to you, Minister.
Thank you very much, Chair. Good morning to you. Good morning, honorable members, everybody who is here, the Director General of the department. Apologies from the DM, we have split. He is today attending the Cabinet Committee while I'm attending the Portfolio Committee, so that we try and ensure that both of us can still be able to appear both ways in terms of our work. With us, we've got the Director General of the department who is joining, and also DDG Calais, who is, this work is under her portfolio. I won't introduce all the colleagues who are here today, but just to say the two who are part of our delegation today, Chair. We are bringing the Judicial and Constitutional Development Amendment Matters Bill.
Minister?
Yebo?
In your camera, you are just appearing from a corner, the bottom corner. Can you adjust your appearance?
Is it better now? Oh, I still have my background of Freedom Day. I must change it to Africa. I'll remove the background. I think that's what is.
Yeah, that's better. That's better.
Okay, thank you very much, Chair. Yeah, I was saying that we bring in these amendments. I must say, Chair, while we bring these amendments, just to bring it to attention, I had the meeting with LPC. There were issues that they wanted into the amendments, which we didn't put in this amendment. Just to flag it, perhaps it will come during the public hearings or your interaction with processing this. We have assured them that we'll attend to it. We had staggered, there are still issues that we need to deal with in those areas that are not yet covered. It's not that we are not paying attention to them. So we are dealing with those, Chair. I think currently what we have is surfaces to what we were able to process, and we are ready to process through the committee in terms of the amendment to the JSC and the amendment to some of the issues that even relating to LPC. So I thought, let me just flag that. I won't go much into detail, just to save and say, we haven't as well on the budget, Chair, while I'm here, we haven't received any indication whether our budget will adjust. So Parliament would have written to us as ministers to say that based on the adjusted budget or potentially reduction or whatever that could happen with the budget, we might be required to retable. So far where we are sitting, there hasn't been a formal letter to either myself, I've checked with the CFO, no communication has been received relating to adjustment to what we have already been given as an indication. But to play within the safer process, because the matter is not served before Cabinet, it will only serve next week. We will wait for that process, Chair, to indicate, and we are hoping that we don't have to retable and we can be able to proceed with our budget and our IAPPs and strat plan in the manner that they've been done. What I have received assurance from Minister of Finance is that the budget at the Office of the Chief Justice, as it has been increased, it will not change. So that budget will remain the way it has been given as indication. His belief is that, yes, there is a need for us to start paying attention to that area of the budget so that there are no challenges there. So I thought, as you flagged the issue of the budget, Chair, even from my side, let me just quickly flag it in terms of the conversations and the discussions, but we'll be willing and available to do. We have received dates from the Leader of Government Business in terms of indication for the budget vote debates for both Office of the Chief Justice and the department's budget vote. So we'll make sure that we do our best, noting that there will be pressure to avail ourselves and prioritize, but also to ensure that we can cooperate with the committee to meet the demands. I won't go into detail with the others, Chair. I just thought, let me flag those and then allow the team to make the presentation, and we'll deal with the issues afterwards. Thank you.
Thank you very much.
I'll hand over to the DG so that he can proceed with the presentation with the DDG. Clear.
Thank you very much, Director General.
Thank you very much, Chair, and thanks to the Minister and honorable members. I won't take much time. I'll ask the DG Kale to flag and take the committee through the presentation. Thank you.
DG Pillay.
Good morning, Chairperson, Minister, DG, honorable members, and the colleagues online. This morning, Chairperson, we will be doing the judicial matters amendment matters. Judicial matters amendment bill. And I will flight the presentation.
DG Pillay, can you hear me?
Yes, I can hear you, Chair. Can you hear me?
Yeah, you were cutting a little bit when you were starting, but it seems like it has improved now. Proceed. We'll see.
Chair, I'm going to switch off my video. Maybe that will assist.
Yeah, please.
Thank you, Chair. Chair, I'm going to do a brief overview of what this legislation is about. I'm just checking if my slides are, you're able to view my slides.
Yes, they are on the screen.
Okay, thank you very much. Chair, the bill is a mixture of numerous pieces of legislation that we wish to amend. And it is the purpose of doing these amendments is to increase efficiency in the justice system and to also tweak certain pieces of legislation that requires amendment. much of the amendments are non-contentious in nature. Also in this particular amendment bill, we also seek to correct to implement a constitutional court order in the Arena Holdings constitutional court case. And Chairperson, so as I've indicated, the amendments addresses practical and technical issues of a non-contentious nature. And I think we will now move on to the clause-by-clause discussion. Chairperson, please allow me to introduce Mr. Takalani Nanduleni, who's a person who has not appeared before the committee before, but he is a senior state law advisor, and he is going to take us through this presentation very quickly. He is in charge of this particular legislation, but we are supported by other officials, namely the chief director and two other seniors who have also participated in the drafting of some of the amendments. So may I ask Mr. Nanduleni to take us through the presentation? I will keep flighting the presentation if that's permissible, Chair.
Yes, Mr. Nanduleni, can you appear before us?
Like the DDG has indicated, my name is Takalani Nanduleni. I'm the Senior State Law Advisor at the Department of Justice and Constitutional Development, responsible for drafting of legislation.
We can't see you.
Chairperson, unfortunately.
The indication is that it is the first time you are appearing before the committee, so we'd like to see. All we see is a name written Takalani.
My apology, Chairperson. I'm connecting through a cell phone because my laptop has a computer network problem. If I can be allowed to proceed, Chairperson.
You can just show yourself, then proceed. Oh yeah, we can see you now. Okay, you can switch off your video now, then proceed. Thank you.
Okay, thank you, Chairperson. Chairperson, Clause 1 of the bill amends Section 8 of the Judicial Service Commission Act to revise the composition of the Judicial Conduct Committee by increasing the number of members of committee. Chairperson, if you look at or check Section 8 of the Judicial Service Commission Act, it provides that the Judicial Conduct Committee will consist of the Chief Justice, who is the chairperson, Deputy Chief Justice, the Deputy Chairperson, and 4 judges. So the purpose of the amendment, Chairperson, is to increase the number of judges from 4 to 8, and to empower the chairperson to appoint not more than 3 temporary judges to deal with backlog. This proposal we received from the Office of the Chief Justice Chairperson, and we don't have a problem as a department.
My apologies, Member Matafa speaking.
Honorable Matafa.
Thank you very much, Chair. Good morning, Minister, and everybody on the platform. Chair, I'm not sure if whether the intention from Takalani is to have the presentation moving, because I hear it seems as if it's already in the content of the presentation, but we're still on the first slide, which is
the indication was that the person was responsible for co-hosting is DDG Pillay. DDG Pillay?
Thank you, Chair.
Thank you, Honorable Matafa. DDG Pillay?
And
are you able to move the slides?
Chair?
Yes.
Good morning to everyone. Chair, I think Mr. Takalani is very quick man when speaking, so we're going to struggle to capture what he's saying. I know maybe it's how he speaks, but can we please request him just to slow down a bit? Thank you.
Mr. Takalani, you don't travel at 220 kilometers per hour. Pile, are you able to move the slides? The flighting is gone. Yeah,
Chair, is it now visible?
yeah, it's back now. Can you move it so that we see if it's moving? Can you scroll up? Yeah, it's still the same first page presentation.
Yeah,
To
I'm
the
just a bit concerned because I seem to be on the sharing, but it's not sharing that particular presentation.
Committee Secretary, are we able to assist?
Yes, Chairperson, let me try from my side.
Yeah,
Is
please
it
try.
moving now?
No, let's give the Committee Secretary to try from his end. It's not moving from your side.
Okay.
Can you scroll up so that we see if it's moving? Yeah, it's moving now. It's moving now. Thank you, Committee Secretary. Mr. Tagalan will indicate which slide you were in. I guess you were in slide 2. Mr. Tagalan, you can proceed and of course consider what Honorable Mhlala was requesting.
Chair, it's actually slide 4. So may I
Slide
ask,
4.
yes.
Slide 4, okay. Go to slide 4, Committee Secretary.
4.
Okay. Mr. Tagalani, you may proceed.
Thank you, Chairperson. I was on clause 1 of the bill, and I was trying to explain to say clause 1 of the bill amends Section 8 of the Judicial Service Commission Act 1994 to revise the composition of the Judicial Committee by increasing the number of members of the committee. Chairperson, Section 8 of the Judicial Service Commission Act provide that the Judicial Conduct Committee will consist of the Chief Justice, who is the chairperson of the committee, and Deputy Chief Justice, who is the Deputy Chairperson of the committee, and 4 judges. So the aim of the amendment is to increase the number of judges from 4 to 8, and the chairperson, and to empower the chairperson also to appoint not more than 3 temporary judges to deal with backlogs. So I was also trying to explain to say this proposal came from the Office of the Chief Justice, and the department agreed with the proposal. So moving to clause 2 of the bill, Chairperson, it amends another act, which is the Promotion of Access to Information Act, and amends Section 14 of that act to make provision for the manual to also contain the website.
Mr. Tagalani.
Sorry, Chairperson.
It seems like you are also cutting on that side. Members, is it on my side or everyone can hear that Mr. Tagalani is cutting?
The stuff is problematic, Chair.
Yeah. Can you try to move a bit, Mr. Tagalani, to improve your bandwidth?
Okay, Chairperson. Can I proceed, Chairperson?
Yes, we can proceed now.
Clause 2 of the bill also amends Section 14 of the Promotion of Access to Information Act 2000 to make provision for the manual to also contain the website link to the latest notice regarding the records held by the public body that are automatically available in terms of buyer. So, Chairperson, this proposed amendments to 6 only to insert the website link in the Section 14, subsection 1B of buyer. Clause 3 of the bill, Chairperson, only deletes incorrect reference in Section 15 of buyer. Clause 4 of the bill amends Section 16 of buyer so as to transfer the responsibility of keeping the register and publishing information from the Director General of all national departments responsible for government communication and information services to the information regulator established in terms of Section 39 of the Protection of Personal Information Act. So, Chairperson, the amendment here is only to transfer the responsibility from the Director of Communication to the Information Regulator as established in terms of the Protection of Personal Information Act. So, Clause 5 of the bill, Chairperson, includes
Yeah, we lost
the
you.
designation of the person as Deputy Information Officer in terms of
Mr.
Section
Tagalani?
17 of yes, person, we are just amending the content.
We keep on losing you.
Chairperson.
You said clause 4 of the bill. Then you got lost. Then you came back in the mid of the sentence. I'm just alerting you so you know. You may proceed, but please try to locate a proper space to improve the network.
Chair, I'm sorry, it's Glenys. May I add something?
Yes, you can add, Honorable Glenys.
Thank you. Mr. Takalani is still proceeding at a very fast pace.
Okay.
I know that's probably difficult, but if you could just try and slow down a little bit.
Okay, thanks, Honorable Bredenbach. Mr. Tagalani, can you hear us from your side?
Yes, Chairperson. I will try to slow down.
Yes, please.
Uh,
Please.
yeah,
There's a second request now that you slow down.
Okay. It's not a Chairperson. So
we understand sometimes it's issues of nature, but please try to adjust.
Okay, Chairperson, it's noted. So I'll go back to clause 4, Chairperson. I was explaining to say clause 4 of the bill amends section 16 of PIA so as to transfer the responsibilities of keeping the register and publishing information from the Director General of all national departments responsible for government communication and information service to the information regulator established in terms of section 39 of the Protection of Personal Information Act to transfer that responsibility that is provided in section 16 of PIA to the information regulator established in terms of section 39 of the Protection of Personal Information Act. So moving to clause 5, Chairperson of the bill is to include designation of person as Deputy Information Officer in terms of section 17 of PIA to designation and delegation of persons as Deputy Information Officer. So, but the contents only talks about delegation. So we're just clarifying that omission and include designation in the contents of section 17 of PIA. So moving to the next slide, which is clause 6 of the bill. Chairperson, clause 6 of the bill seeks to clarify that section 35 of PIA applies to section 46 of PIA. So if you check section 35 of PIA, Chairperson, provide for the mandatory protection of certain records of SARS, which is South African Revenue Service, whereas section 46 provides for the mandatory disclosure of records held by or records for public interest, arena holdings, regarding the constitutional challenge to determine whether tax information held by the state received absolute protection from the disclosure under PIA. So the court ruled that the right to privacy and secrecy did not fulfill the limitation test as set out in section 36 of the Constitution. So the amendment, Chairperson, in this regard, seeks to comply with the Constitutional Court judgment in Arena versus South African Revenue Service, which declared section 35 and 46 of PIA unconstitutional. to the extent that they preclude access to tax record by a person other than the taxpayer, even in circumstances where the requirements of Section 46 of PAIA are met. Chairperson, you will note that this is a Constitutional Court judgment, and normally they will give the time frame for Parliament to correct that declaration of invalidity. So in this case, Chairperson, the deadline for compliance with the judgment is 29 May 2025, and it looks like we failed to comply with the judgment in this regard. But however, Chairperson, there's a reading in provision in the judgment to the Tax Administration Act. So, Chairperson, we don't need to worry about the failure to meet the deadline, because there is a reading in the judgment. So, moving to clause 7.
Mr. Tagalani, can you repeat that part of the deadline and the reading provision that which Parliament should not worry?
Yeah, I was just saying, Chairperson, in the judgment there is a deadline for compliance with the judgment, which is 29 May 2025. But I was trying to explain to say in the judgment there's a ready-in provision to the Tax and Administration Act.
No. Is the deadline not supposed to be a deadline for Parliament to have completed in curing the defect?
That's what I'm saying, Chairperson. To say that the deadline for Parliament was 29 May 2025.
So you mean from today, the 7th, we have Parliament has got until the 29th of May to complete the entire process of lawmaking?
Chair, if I may come in, my hand is raised, please.
Yes, please come in only on that part.
Thank you, Chair. There is a reading in, which means there won't be a lacuna in the law, and the reading in will address the defect. And the amendment that we seek to make is a simple inclusion of the section into the primary legislation. So it won't have a negative impact.
Wait. In the normal course of events, a court of law declares a particular provision in law unconstitutional, then gives Parliament 24 months to cure the defect. Then because that provision has been declared unconstitutional, so the reading in provision is supposed to be a serving provision in the period of 24 months. So are you saying the reading in provision will extend beyond the 29th of May?
The reading in provision cures the defect. It doesn't extend the period within which the matter must be addressed. It cures the defect that the Constitutional Court has found. So there isn't a lacuna or a gap in the law. The provision, as we are seeking to amend officially,
that's the
continue
point.
to apply.
That's the point, DDG. That's the point. There is a reading in provision that kicks in the day the judgment is handed down until the time Parliament cures the defect. So Mr. Tagalani says we shouldn't worry about the deadline of the 29th of May because there's a reading in provision. Now, the point we're raising is the reading in provision not lapsing with the same 24 months, which is the 29th of May? So when you say we must not worry, you mean the reading in provision is going to surpass the 29th of May?
That is my understanding, Chairperson, but we will confer on that matter and revert to the committee on the particular section of that order, and we will come back to it.
Okay, members, just take note of that. When you indirect, just come for.
Sorry to interrupt, Chairperson. It's Judicial. I can't raise my hand just to assist, if I may.
No, let's do like this. Let's do it like this, Mr. Tsiedzi. I wanted to understand what Mr. Tagalani was saying. I didn't understand what he was saying, so he was explaining it. So what we must do, members, can you take down your hands as well? Let's allow them to finish. Then we're going to interact with that particular thing as the first issue. Proceed, Mr. Tagalani.
Thank you, Chairperson. Clause 7 of the bill, Chairperson, amends Section 26 of the Prevention and Combating of Corrupt Activities Act 2004, in order for penalties referred to in Section 26(1)(c) to apply to a contravention stipulated in Section 34A, which makes provision for the failure of members of private sector or incorporated state-owned entities to prevent corrupt activities. So the purpose of the amendment, Chairperson, is to make penalties listed in Section 26 to apply to offense stipulated in Section 34A, Chairperson. So moving to Clause 8 of the bill, Chairperson. Clause 8 of the bill, the next slide, DDG, or the secretary, committee secretary. Slide 7. Yes, Clause 8 of the bill seeks to amend Section 9 of the Child Justice Act 2008 to provide that where police officials has a reason to believe that a child under the age of 18 is suspected of having committed a crime referred in the Cannabis for Private Purpose Act 2024, they may not arrest the child. So the police official must hand over a child to, amongst others, an appropriate person or a guardian, and must notify the probation officers. Chairperson, the purpose of the amendment is to align the offense committed by a child in terms of the Cannabis Act with the Child Justice Act regarding dealing with the child. And we're saying, we're providing that whether that a child committed that offense, the police official must not arrest the child, but they must hand over a child to, amongst other, an appropriate person, a parent or a guardian, and must notify a probation officers. Clause 9, Chairperson, is the same principle, so I don't think I must repeat it because it's the consequential amendment, just to align the offense committed by the child in terms of the Cannabis Act with the Child Justice Act, as I explained previously, relating to Clause 8 of the bill. So moving again to Clause 13 of the bill is the same consequential amendment, Chairperson, just to align the Cannabis Act and together with the Child Justice Act, Chairperson. Clause 14 of the bill propose the deletion of the definition of Justice Center, and also to replace that Justice Center with a legal aid office, and also to add new definition that we are using in this Judicial Matters Amendment Bill. So we are adding another definition, like the definition of the Commission for Gender Equality, the Legal Aid South Africa, and the Special Investigating Unit in the definition of the Legal Practice Act. So Clause 15 amends Section 25 of the Legal Practice Act to provide for the automatic right of appearance in any court in the Republic for legal practitioners. Provision for an extension of the right of appearance is made for candidate attorneys and pupils whose practical vocational training contract is expired, but who have not been admitted as yet. Chairperson, here we're just adding sorry, Chairperson, we're just adding the provided the extension by only 6 months, but this will empower or will enable them to remain in the employment until admission. So we're just adding the 6-month period in the Legal Practice Act. So moving to Clause 16 of the bill, Chairperson. Clause 16 of the bill amends Section 26 of the Legal Practice Act to clarify the requirement for admission and enrollment as a legal practitioner as LLB degree. Chairperson, here we're just only removing, because if the principal act is defining the LLB and also the period of studying the LLB. So now we are just deleting the period of study for the LLB. We're just indicating to say the requirements will be only the LLB degree. We're deleting that period because the act is talking about 4 years and 5 years of LLB degree. So there's that technical amendment that we're clarifying. So Clause 17 of the bill amends Section 29 of the Legal Practice Act in order to include community service for practical vocational training at the Commission for Gender Equality, or state institution approved by the minister by notice in the Gazette, Chairperson, for candidate legal practitioners. So clause 18 of the bill seeks to effect consequential amendment to section 30 of the Legal Practice Act by deleting the responsibility of the council to keep information relating to the right of appearance, Chairperson. So moving to clause 19 of the bill, which is slide 11, Chairperson. Clause 19 of the bill seeks to delete obsolete terminologies in section 34 of the Legal Practice Act. So, Chairperson, like I indicated in the definition, we are removing the word justice centers in the Principal Act. So the proposed amendment makes provision for the attorneys to share or divide their professional fee with attorneys. In addition, Chairperson, the proposed amendment also makes provision for employees of the Commission for Gender Equality or any state institution referred to in Chapter 9 of the Constitution as approved by the minister by notice in the Gazette, and the Special Investigating Unit, who are admitted as attorneys and advocates to practice as such. Chairperson, the provision will only allow those employees who are admitted as attorneys and advocates to practice within the entities or the institution that they are employed. They are not going to be allowed to practice outside those institutions. So, Chairperson, you will note in the presentation that we indicated that following the introduction of the bill to Parliament, the South African Revenue Service has also requested an amendment to Section 34, which is the very same section, Chairperson, of the Legal Practice Act, to include the admitted attorneys and advocates to practice as such, particularly within their tax courts. So, Chairperson, the department doesn't have an objection regarding the proposal by SARS, but we are requesting your indulgence that this request may be dealt with during the deliberation on the bill, Chairperson. So we're just indicating that the SARS has also requested the inclusion of their own attorneys and advocates to be allowed to practice within their own tax courts. But they've done that after we have introduced the bill. So we are requesting the Chairperson, the members also to also consider that request during the deliberation of the bill. So moving to this very same, but to other aspect of the amendment, Chairperson, provision is also made for directors of commercial jurisdiction entities who conduct legal practice to be jointly liable for any theft committed by them during their term of office. So moving, Chairperson, to clause 20 of the bill. Clause 20 of the bill amends section. Yes, Chairperson. Clause 20 of the bill amends section 84 of the Legal Practice Act to make provision for the exemption of a legal practitioner who practices as a part of law clinic from the requirement of possessing a fidelity fund certificate insofar as it pertains to legal service rendered by that legal practitioner at the law clinic. Chairperson, clause 21 of the bill amends the definition of police officials in section 21 of the Cybercrimes Act 2020 to include any officials who by virtue of their office is authorized in terms of the provision of any other law to investigate an offense in terms of any law where such investigation relates to search, access, or seize of an article as defined in section 1 of the Cybercrimes Act. This will empower an investigator and their regulatory authority to investigate, search, and access and seize electronic items in terms of Chapter 4 of the Cybercrimes Act in respect of criminal offense falling within their mandate. Chairperson, this amendment is just extending the definition of police officials to allow other investigators appointed in other legislation also to be able to enforce Chapter 4 of the Cybercrimes Act, Chairperson. So moving to clause 24 of the bill, Chairperson, this is just to empower the minister to make regulation relating to the form and manner of application for such warrant, Chairperson. And the clause 23 of the bill contains the short title, Chairperson. And that's all from me, Chairperson. Thank you very much.
Thank you very much, Mr. Takalani. for that presentation. Members, can we interact now with the presentation as it is? The presentation seeks to amend 6 pieces of legislation as outlined in the presentation. So we'll take Honorable Reitenbach, Honorable Swart, Honorable Glober, Honorable Matafa, Honorable Sotetse, Honorable Nomvalo, and Honorable Shala. Honorable Bredenbach, you can proceed.
Thank you, Chair, and good morning to everybody on the platform. Chair, yeah, so I have a number of issues I want to raise. The amendments to Section 8(1) of the JSC Act and the new proposed section, they do not address the dire shortages in the Secretariat of the particularly the Judicial Conduct Committee's arena within the JSC, and that also contributes to the slow pace. And unless we do a more comprehensive, take a more comprehensive approach to legislation, we're not going to address the pressing issues that cause these systemic delays. So, you know, the proposed amendment does not deal with all of the issues besetting the JSC. And once again, this piece of legislation represents the general approach by the department, which I find both unacceptable and quite concerning, of doing sort of a patch-up of amendments. So the Constitutional Court orders amendments, not only of this act, but of the other acts that we're dealing with today. And it gives a time period, and those time periods are, for some reason, largely ignored. There's a casual approach to bringing these things to Parliament, it appears. And then the committee is forced, under pressure of time, because we don't want to be in violation of the Constitutional Court, and we don't want to continuously ask for extensions. So we're forced to condone this slapdash sticking plaster approach, which is, it's just not effective, it's not efficient, and it's not a good and effective use of resources. And so now we're going to once again be forced to deal with these issues within a very short space of time, and not deal with the real issues within the legislation that require dealing with. And so I find that approach problematic, and I'd like the department to comment on it. And while they're commenting on that, I'd like to know what the current position is with regards to the composition of the legislative unit in the department. How many people do they have? What is the experience level of those people? We all know that they have had people retire. Sadly, people have passed away. What is the position with that unit, and are they able to comprehensively deal with legislation? Why is it that this committee is constantly beset with legislation that's brought late, and then we're under pressure to approve it, accept the legislation, accept the piecemeal approach to amending legislation, instead of taking a much broader approach, a much more efficient, comprehensive approach, taking a much more public and participation approach, and getting the job done properly? Why are we always under pressure to pass amendments that are really not, that we all know are not going to solve the problem in the long run. It's always a short-term issue. The department takes the view that the proposed amendments are primarily of a technical nature and remedy constitutional defects where there is already a reading in clause. Well, yes, that is the sticking plaster. It's not acceptable, and the committee has complained about this approach in the past. Nothing is done to change it. We are still, the legislation is still brought, as you correctly, Chair, pointed out now. We're now faced with a very short period of time in which to deal with this matter. And this happens all the time. We've complained before, and we never get an explanation as to why. So I would like an explanation today as to why this is. And I don't want to blame anybody in the department for it. I understand that they're operating under probably huge pressure and probably a massive shortage of resources. But we need to know what those issues are so that we can try and help them address it. The misconduct cases, Chair, of the JSC need to be dealt with much more comprehensively. And this amendment does not deal with the issue comprehensively. So it's not we have little choice, but it's not an answer to all of our problems. We need to have a much more comprehensive approach. This was an opportunity to comprehensively amend all of these pieces of legislation where they have defects that are more easily dealt with, but where we know they have other bigger problems. This was an opportunity to deal with all of those pieces of legislation, bring comprehensive amendments that deal with the issues that we have accumulated over the years, and with hindsight now see that we could have done better. This was the opportunity to do that better, so that for the next couple of years, these pieces of legislation can stand the test of time. But now this isn't going to happen. Now we're doing the sticking plaster approach, which I really, I find it completely unacceptable. And so while I have other comments on the legislation, I'll leave that to my colleagues. I'm sure they'll raise them. What I want from the department is an explanation as to this. How are we going to correct, solve, and improve this approach of piecemeal amendments to legislation that has been a constant over the last sort of 6-7 years, instead of comprehensively addressing issues? Thank you, Chair.
Thank you, Honorable Swart.
Greetings, Chair. Greetings to the Minister, DG, and colleagues from the department. I want to echo my colleague, Advocate Breitenbach's sentiments. Firstly, by saying we fully appreciate the constraints that the department works under when it comes to staff, when it comes to legislative capacity, and we need to bear that in mind. That having been said, this matter of where there are constitutional court deadlines is a perennial problem. It has been raised by myself with the Speaker of Parliament, because it doesn't seem to be only a problem relating to the Justice Department, but across the board. There is a mechanism in place, and I'm sure the department would be aware that the legal advisors to Parliament write regular correspondence. That was the mechanism that was put in place, asking for progress with the tabling of bills where there is a constitutional court deadline. In this present case, we've had 2 years, and we sit in our right at the end of that 2-year period. The Constitutional Court made it very clear that they were deferring to Parliament to allow us time to consider this issue and deliberate on it. Now, yes, there is a reading in provision, which will continue in terms of clause 5 of the judgment, which says in the event that Parliament does not remedy the constitutional defects within 24 months of this order, paragraph 4, which is the reading in provision, shall continue to apply. So it is not like other matters such as the RECA bill, which was not signed in time by the President, and there was now a gap in the law. But Chair, we need to really emphasize to the department, because this is a matter that will be now dealt with at a high level by the Speaker with the leader of government business, to ensure that Constitutional Court deadlines across the board are met in much earlier timeframes, that Parliament is given sufficient time to properly consider Constitutional Court deadlines, given the fact that the order is against Parliament. And in this new administration, in this new Parliament, it's going to be imperative that we meet Constitutional Court deadlines. And I would request, besides the issues relating to this particular matter, that we get a list so that we, from the committee's perspective, can also monitor where there are Constitutional Court deadlines. I think it's unacceptable that we are now forced to consider this where the cutoff date is within a few days, weeks. That having been said, Chair, it seems that there is largely, it's uncontentious when it comes to this SARS amendment, but we do need to apply our minds very, very in detail, given the fact that the Constitutional Court suspended the declaration for 24 months, deferring to Parliament and making it very clear that Parliament needs to apply its mind to this matter. Chair, as far as the misconduct cases of the JSC are concerned, I also, and I'm sure other members on the committee, share Advocate Breitenbach's concerns about the time that is being taken to deal with these matters and the concerns about the shortages in the Secretariat. My particular question is, and I'm sure it might be clarified, is the addition from 4 to 8 judges, and then one presumes from the presentation that there'll be space for an additional 3 temporary judges. I just need clarity in that regard. Does that mean then, in effect, that there could be 8 plus 3 to deal with these backlogs? Chair, thank you. Those are my submissions from my side for the time being. We will definitely be commenting on the other amendments that have been proposed.
Thank you, Honorable Swart. Honorable Klopper.
Thank you, Chairperson. I hope I'm audible. Chairperson, I won't echo too much of what my colleagues have said. The only question I have 3 questions. First one relates to the increasing of judges, as previously alluded to, from 4 to 8 in the JCC. What I would like to know, would this actually significantly speed up the handling of the complaints? And I'm asking this considering that it is mentioned that 4 of the judges that are currently sitting are full-time judges, and this is what causes the delay. And my question is, the 4 additional ones, and I'm not talking about the other 3 additional, just the 4 to 8, would they also be full-time judges? And does this offer maybe just a slight boost, or does it in productivity, or rather substantial improvement? So that would be my first question. Just to understand better the recognition of the law graduates, I would just like to know, why is the B.Proc degree not included in the proposed amendments? Is there a reason for this, that it's just the LLB students? If you could just give me clarity on that. And Chairperson, the last question I have relates to the Cyber Crimes Act amendments. The definition of the police official is being broadened. Is this expansion about investigative efficiency? And is there a possibility that this could be used as a backdoor to unchecked digital surveillance powers? How will this be managed, and how will it be mitigated? Thank you, Chair.
Thank you, Honorable Klopper. Honorable Matava.
Thank you very much, Chair. Let me take this opportunity to greet once again to you, Chair, the Minister, and the team, honorable members. Chair, I'm going to be very brief, starting by just asking a direct question, because there was no extensive consultation in preparing the draft of the bill. As the department indicates that it's mainly technical amendments. Are we sure that all the provisions and changes that we are bringing on will pass the constitutional muster? Are they fully constitutionally compliant. I'll cite an example, Chair. On the clause that speaks about bail conditions, are we sure that the provisions or amendments that we are bringing would not infringe on the constitutional right of the accused? I'm asking this question, Chair, remembering the next item on the legal opinion that we will receive, that we are going to receive rather, where there was a reservation about the rights of the subject of surveillance. So as much as we want to strengthen the protection of the victim, but we must also be mindful of the constitutional right of the accused. So I just want to check, is there constitutional compliance as far as the bill is concerned in its totality? Chair, let me join the chorus on speaking about the JSC and agree with the former speakers who emphasized the need to respond timelessly on court judgments so that the committee and parliament are not put under pressure when the time remaining to comply with the court order is nearer to the time that the parliamentary process is started. Again, to underscore the observation raised by Advocate Bredenbach in terms of a piecemeal approach in dealing with legislative amendments, we would have had sight of a report by Freedom Under Law when it investigated the activities in the JSC. I think it's 2008 to 2022, where it states that the system in the JSC is broken. And as such, it is recommending an overhaul of all the provisions of the JSC Act. Now, this piecemeal approach, does it remedy all the areas of this broken system, like it was stated on the issue of strengthening the secretariat? One other thing, Chair, we can speak about is the lack of clearer guidelines for the appointment, promotion, and transfer of judicial officers. And we believe that if these guidelines are there, the JSC will be easily held accountable to its decisions, because there will be a yardstick through which you will be able to measure the performance by the entity as well as by those judicial officers. So, Chair, I only have those 2 points that I wanted to raise, and that one direct question of constitutionality of the entire bill, as it will go to public consultation as well. Thank you very much, Chair.
Thank you, Honorable Matafa. Honorable Tsoteti.
Thank you very much, Chair. And let me greet everyone in the platform. First, Chair, look, I am partly covered by the speakers who came before me, particularly on the matters that have been dealt with by the court, and order being that Parliament must be able to resolve within a particular time period. I would have wanted to say that perhaps we must get a sense of how many are those matters that are sitting with the department now, and be made aware so that at the level of the committee, we are also able to perhaps make the necessary follow-up and keep them in check so that we can be compliant with the directives of the court. The second one, Chair, which I would have wanted to deposit, is actually a clarity-seeking question. To say that in clause 19, where it speaks about making provision for employees of the Commission on Gender Equality, mainly in the sense of Chapter 9 institutions, is there any specific reason that we limit this provision to the Chapter 9 institutions? I'm asking this, Chair, because what we would have noted is that the Auditor General always decries the use of external people. It might be on the legal matters, it might be on other areas where government normally utilizes the consultants and so forth. Is there any reason why this clause cannot cover the utilization of the internal employees on other entities who are equally qualified as attorneys and other law or legal professions for the task of we are amending clause 9.4. And if that is the case, why aren't we extending it to cover such entities? The example in case you'd find that I'll take municipalities. You would find that they do have a legal unit of their own, fully equipped with highly qualified individuals, but they still will be expected to utilize external forces, even for minor matters that could have been easily resolved internally by the use of this. So that's the question, whether is there any specific reason why we limit this to Chapter 9 institutions? Thank you very much.
Thank you. Honorable Nomvalo.
Thank you very much, Chair, and greetings to everyone who is part of this meeting. I'll try not to fall into a temptation of deliberating on these proposed amendments, even though the temptation is there. Chairperson, I think I just want to first express that the unease that I have from a general point of view about this presentation is that, one, except on the amendments which have been directed by the Constitutional Court, is that on the other amendments, we do little, or the presentation is doing little to explain the mischief that the amendments seek to address. Because I think we must espouse a general approach, a standard approach of saying, when these presentations are made, they must also explain that this is what we have identified, and this is what this amendment seeks to address, and close if there's any legal gap. And also the consultations that have been made in effecting that proposal. Who has been consulted, the stakeholders, for instance, on the issues which relate to the LPC, which is the Legal Practice Act. So who has been, except the LPC, because there are many stakeholders that the Act regulates. So consultation, I think, is very important, and the presentation must also give an explanation to that effect. So my proposal, Chair, is that in the next presentations, we must be told the mischiefs, because that is a golden rule for any creation of any statute, that we must know the mischief and that has been identified, and an explanation of how this proposed amendment will address that mischief must be given. So that is the first point. Then the second point relates to the extension of the right of appearance of 6 months beyond the articles of clerkship or the articles. Have you done a research of how long does a application for admission takes after the candidate attorney has completed their articles? Because as far as I know, in some instances, the application takes, because of the inability to secure a sooner date. So some applications go beyond 6 months, and that is a prejudice to candidates, attorneys, because it means when there's no right of appearance, while they have not been rightfully admitted by the court of law, then that means they have nothing to do because they can't appear in any court while they qualify to do so. But the only thing which is an impediment is that they have not been rightfully admitted. So according to a research that we have made, is this 6 months that we are proposing enough to address that prejudice? And then I think Honorable Matafa is partly addressed what I wanted to address as a clarity-seeking question. The issue of ensuring that the proposed amendments are in line with the Constitution. But I'll come from a different point of view. My question is, have you outsourced any legal advice on these proposed bills, either from any legal or from any senior counsel or junior counsel, to ensure that we do not face what we are currently faced with, of a situation where the president takes matter back to court because he has some reservations about the bill. So have you done some research? And then I think also what I wanted to ask about, because it has not been, I think it has not been clear because there were technical glitches. I was struggling to hear Mr. Tagalani. And I think I lost him when he was explaining the issue of proposed addition of 4 judges to make 8, and the proposed discretion that must be given to the Chief Justice to appoint other 3 judges. Now the question is, will that make a total of 11 judges, 8 plus 3? So I need clarity on that. And the last question, Chair, is on the. No, I think I've covered all my questions. Thank you very much.
Thank you, Honorable Mvalo. Honorable Mhlala.
No, good morning, Chairperson. Let me take an opportunity and greet all members of the Portfolio Committee before I can start raising my question. Chair, my first focus is going to be on clause 1, which speaks to the expansion of the Judicial Conduct Committee. Chair, we can see there the amendment is talking about, the proposed amendment is talking about the increasing of the JCC from 4 to 8 judges with at least 4 women, and allowing temporary appointments can help can help address the backlog and gender representation. So, Chair, my concern is the said legislation still relies on active judges, because when you go to the presentation, the reason why I think we are amending this particular legislation is because complaints are taking forever to be finalized. But the legislation also, the proposed legislation still speaks of relying on active judges. I think the reason why we are having backlogs, cases are taking forever to be finalized, is because of relying on active judges. The JCC remains composed of sitting judges who have limited time and competing priorities, causing several delays. They even mentioned the case of Makubele, which takes 4 years to reach tribunal. And my other concern is there is no dedicated full-time staff to process complaints, despite recommendation by Freedom Under Law and Judges Matter. The timelines also, the bill does not introduce mandatory deadlines for resolving complaints, allowing indefinite delays. So, Chairperson, my question is, why does the bill not create a full-time independent secretariat to process complaints as recommended by multiple civil society reports? Without timelines, how will the bill prevent the kind of multi-year delays that have plagued the JCC and denied justice to victims? And lastly, Chairperson, why is the bill not overruling the entire JSC Act, given that it predates the Constitution and is widely acknowledged as structurally outdated? I'm going to end there, Chairperson. That is the only questions I'm having for now in terms of amendment of this particular bill. Another thing, Chair, before I can close, I heard the minister when opening speaking about the budget, and she mentioned that she doesn't think that our budget will be tabled again because there's no amendments on the budget. I couldn't hear her clearly, because I think now everything is going to be, Chairperson, as per our thoughts and as per what we know. The budget must be tabled again by the Minister of Finance. And because I think the expenditure will reduce, there's a lot of things that will reduce, which will also affect our budget as the Portfolio Committee of Justice and Constitutional Development. And I heard the minister saying that she doesn't think that our budget is going to be retabled. Can she maybe repeat again so that we can hear clearly? I couldn't hear or understand exactly what she's talking about. Can she clarify us on that matter? Thank you, Chair.
No, she was talking about a particular appropriation to budget vote 27 and 25, which is the department and the Office of the Chief Justice, that they have not currently received any indication from the National Treasury if the then arrangement is going to change in line with the current arrangement of the budget. She was not saying it won't be tabled again. It will be tabled again on the 21st, but it was specifically on justice. That are there any changes in terms of the earlier budgeted issue in relation to the current reworked budget? That was the issue, but I'm sure she's going to go further to that. Just two quick things. the issue of the consultation or Nomvalo is talking about is very important. Take us through your consultation process. This is very important because we're going to undergo our own consultation process, and part of the issues usually we get when we do the public consultation process, they will complain about the department. The department did not consult us on this, the department this and that, consulted those ones and not us. So we always get those kind of complaints. So if you can take us through the consultation process that you would have undergo. The second issue is the issue that relates to the candidate legal attorneys. Look, I think it is the intention to increase the period for the right of appearance beyond the 2 years of article or clerkship is quite received warmly. But I think maybe what we can apply our mind on is the issue relating that will the 6 months actually be able to rescue these candidate attorneys from all these things that they are facing. Because if you recall that the attorneys board examination sits 2 times a year, before June and after June. What happens if okay, my issue is that will the 6 months be sufficient for us to address this matter of a right of appearance exceeding the period of the contract of clerkship, considering what Nomvalo is also saying of a congested role of our courts when a candidate attorney or a pupil makes an application to the High Court for admission, it takes its own time as well. So maybe if you can reflect from that, this is how we're going to do it, Minister. We're going to take the DG and the team to respond specifically on issues relating to the content of the presentation. Then we'll take you last to do the parting shots. DG.
Thank you very much, Chair. I'll ask DDJ Kale Pillay to deal with the specific question. I'll come back later to deal with the issues around the capacity.
DDJ Pillay.
Thank you very much, DG and Chairperson. I think let me start with the issue of these being piecemeal amendments. I know that there is room for improvement in terms of promotion of these kind of amendments from the comments of the Chairperson, for the comments of the honourable members, but I do want to point out that the Judicial Matters Amendments Bill is something that we promote quite regularly because of the number of pieces of legislation the department is mandated to deal with. But as I indicated early on, it's very specific in terms of its purpose. 1, it must be non-contentious. 2, it must be technical, and it must bring about some much needed change in terms of efficiency and in both the civil and criminal justice system. And in this regard, we rely on our stakeholders to give us inputs on what they require to be changed in terms that can be done quickly, that will not require much consultation with the public because it doesn't affect the public in a sense, but also it must not have financial implications, which will then becomes a protracted process, especially in the past few years in terms of budget constraints. So I think those are some of the issues that we look at when we choose an amendment that would go and how we would frame an amendment. So we do it in a piecemeal manner because we amend numerous pieces of acts, legislation. And it is not intended to be an overall, for instance, in terms of the provisions related to the Judicial Conduct Committee or PIA, for instance, but only to bring about minor changes. So but those minor changes will have an impact and an effect in terms of the stakeholders. So in moving to the stakeholders for this bill was the LPC, the Information Regulator, the Commission for Gender Equality, the SIU, who came in respect of the one amendment, and of course the Office of the Chief Justice in respect of the Judicial Conduct Committee. And in the letter from the, let me deal with the comments in respect of the Judicial Conduct Committee and why it is of such a limited nature, and it does not deal with issues about the Secretariat. The Chief Justice wrote to the Minister in respect of the amendments that were required, and the immediate urgent need was identified as the increase in the number of judges, and also to provide for, I think there was additional members on a temporary basis based on the nature to deal with certain backlogs, and for the appointment to not be more than 6 months. So there was a limitation, but we can delve more deeper into that request when we deal with comments during the public consultation process. But it was a limited request, and it dealt only with the issue of judges. It did not deal with the issue of the Secretariat. And as I indicated earlier, when we look at expanding the nature of the organization and making recommendations for the Secretariat, etc., we don't disagree with the points that having a permanent Secretariat may work better, etc., but it requires much more deliberation, and it's not of the nature of an amendment that would go into the Judicial Matters Amendment Bill. So it is limited in nature and to deal with a specific issue to increase the number of judges. But I'm sure we will deliberate on that when we get to the public consultation process. There was also a question on whether there will be 11 judges. Effectively, the Chief Justice will have the power to now have at least 11 judges. Yes, so that's correct. So from 4 to 11. And then I think, let me deal with the issue of constitutional compliance. So the bill was certified by the Office of the Chief State Law Advisor. And the process that we follow is we get a preliminary certification. And once Cabinet approves the bill, we get a final certification before introduction of the bill. So it's quite a rigorous process of scrutiny that the Chief State Law Advisors undertake in respect of constitutional compliance. But as officials in the legislative unit, we also look at constitutional compliance in terms of what we are drafting, and we engage with the Chief State Law Advisors on concerns that they may have. But I believe that the question around constitutional compliance came around the issue in particular about the cannabis bill and in terms of the rights of children. And I think I want to assure the committee that the issue that we want, what we want to protect is the rights of children as accused persons, because the children should not be arrested. And that was identified as a gap that was not clarified in terms of the Cannabis for Private Purposes Act, although the Child Justice Act does protect children. It says they must not be arrested, you must get a probation officer involved, etc. So to clarify the rights of the child as an accused person, we are bringing in those amendments. Then the other major question was around why limit to Chapter 9 and not go broader. So the history of this amendment comes from the request of the Commission for Gender Equality. And in the previous Attorneys Act, there was a provision that said the South African Human Rights Commission and the Commission for Gender Equality would have the ability to have their legally qualified officials also appear during their hearings and to be able to have the right of appearance as well. But when the Legal Practice Act was enacted, it only provided for the South African Human Rights Commission, which whatever
rationale there was for that. We felt that the Commission for Gender Equality makes out a good case because they also hold public hearings and they also investigate matters. So they have similar powers in terms of their mandate, but they did not have the right of appearance. So therefore, it was only limited to the CGE. And in respect of the Special Investigating Unit, they also made a motivation to say that they employ many legally qualified officials, and they are also with the special tribunal. They should also have the right of appearance to facilitate their appearance in those courts and even in their high courts because of the number of applications that they bring to cancel contracts, etc. So that was permitted. But Chairperson, I think it's very limited in this sense. But to talk about building state capacity in a broader sense and why are we not extending it further, it's a bigger conversation. There are many policy issues, but a definite support for the provision in respect of institutions such as SARS to also build capacity as state institutions to have that right of appearance. And it's limited in respect of those institutions and possibly in the public consultation phase, many other issues will come forward, and I think we can deal with that at that stage. But those were the specific requests that we dealt with in terms of this piece of legislation. And in the process of consultation, Chair, I must add that when we have these stakeholders making these representations, we also go back to the stakeholders after the provision is drafted, and we deal with. We ask the question: does this satisfy the need that you have, the immediate need that you had, that requires this piecemeal amendment before we move on to a more comprehensive revision of your legislation? And I think sometimes these piecemeal amendments assist a lot, because if we look at, for instance, the issue of the candidate attorneys, and moving on to that issue of the candidate attorneys, here we are looking at people who have already finished the practical vocational training period, but they have not been admitted and they are still awaiting those processes. And if you do not allow them that 6 months, they could be out of a job in those 6 months if they don't have the right of appearance, as Honorable Member Nomvalo correctly pointed out, that it has a purpose in mind, and therefore we are fixing it as a piecemeal basis. But there may be room for improvement when we consult. When the portfolio committee consults, there may be commentary that comes also from the Legal Practice Council, the LSSA, who also comments on these kind of matters. And I think we can leave that matter for the consultation process and deliberation on how we deal with that matter on the issue of the period of time that candidate attorneys may be extended for. And then I also want to note the comments of Honorable Nomvalo in respect of the presentation, and why does it deal only with the issue on certain gaps in the presentation, that it does not clearly specify what is the mischief we are trying to deal with. And I accept that, and we will definitely improve going forward. And I think the officials online also have taken note of that. And there's definitely room for improvement in that regard as well, Chairperson. I think insofar as that is concerned, may I now leave it to the DG wanted to address the issue of capacity, and then if necessary, I will come in later if I didn't deal with any of the other questions. Thank you, Chairperson.
Thank you. DG?
Thank you very much, Chair. Maybe just a few issues as well that over and above what the DDG has said, one may need to cover as well. The issue of the candidate legal practitioners being given 6 months. So it will be recalled that if they will have been they will have been candidate attorneys for 12 months or 24 months. So just that period takes into account the time it takes to do an application. We are mindful of the fact that the court rolls are full, but at the same time, since these go to unopposed or as ex parte applications, there's a reasonable chance that they will be completed or they will be admitted within that 6 months. Because anything else, I think now is the question of what is a reasonable period. And the general profession seem to think that 6 months will be reasonable. Because beyond that, then if you go to a year,
DJ?
Yes, Chair.
Right on that point. Has the department made a research on what has been a practice throughout these applications?
No, not to my knowledge.
I think let's make a study so that we don't assume that in 6 months they are expected to be admitted already.
Okay, we can do that, Chair. I was just making the point that even if it was to go beyond to 8 months, 6 months just is reasonable, that you still have right of appearance post saving articles. The second issue relates to what Honorable Matafa raised, and I think I'm not sure if Honorable Novala raised as well, but differently, on constitutionality. And DDG Kale has mentioned that state law advisors certified the bill. But just to make the point that even if you were to get a legal opinion saying to you, you will pass the constitutional muster, it can never be 100% proof, that constitutional proof that it can never be challenged successfully. So we work on that basis that there could still be a challenge successfully or unsuccessfully, but at the least the state law advisors will have certified. So we don't go out and procure an opinion due to cost as well, to check whether there's a different opinion to what the state law advisors will have said. Thirdly, the issue of the capacity that Honorable Glenis Breitenbach has raised as well about the capacity of the unit. The committee will know over the past few years, we have been working on increasing the capacity. But at the same time as well, colleagues leave for different reasons. And recently, I think just last year, we have increased as well the capacity with new colleagues. So in terms of quantity, we will have the new colleagues who will have just come in. But of course, then those that will have been experienced because of either reaching the age of retirement will have left. But we continue to prioritize the section. But if you look at the number of bills that the department has to deal with during a particular term, it will take some time until we get to a point where we will say, in terms of capacity, we are comfortable, we have a reasonable ratio. For now, I think the colleagues are a little bit overburdened, and we continue with the little resources we get from Treasury to make sure that whenever we fill the post, this unit does get prioritized, because the ultimate plan is that we want the unit as well for the broader government, when it's fully capacitated, to play a role. There's a lot of expectation in the security cluster as well to assist the other departments. But for now, we can only do much of the work for the department and continue to increase and prioritize increasing that capacity. Look, the timing as well, and the time it takes us to come to Parliament once Concord has declared certain section unconstitutional. In this specific case, the period also will have fallen. It's not an excuse, but it's worth mentioning, will have fallen through that period of elections and the transition from the 6th administration to the 7th administration, and finally managed to have the letters dispatched to Parliament in February. So I thought that we accept that we could be swifter than what we currently are doing, but just needed to mention that it's not due to some form of inertia, but also these other processes of the state and government. Thank you very much.
Thank you. DDG Pillay, your hand is up.
Yes, I apologize for that, Chair. I just want to mention there's one question.
Also take us through on the consultation process.
Sorry?
Please also take us through on the consultation process you have underwent.
Oh, yes. I mentioned earlier that we consulted with the LPC, the Information Regulator, Commission for Gender Equality, the SIU, and the Judiciary. I didn't mention Legal Aid South Africa. I didn't mention SAPS and the Department of Environmental Affairs in respect of the amendments on the cybercrimes legislation, and for the need to expand the meaning of police official. So we consulted with those stakeholders quite significantly, and those requests, and that involved a lot of engagement with them. And as I said, when we draft the provisions. We also submit those provisions to those stakeholders to get further input before we take the matter further to Cabinet. That's on the issue of consultation. And then there was a question by Honourable Nomvala, which I didn't answer. It was whether we sought legal advice from senior counsel or junior counsel in addition to the work that we did with the Chief State Office of the Chief State Law Advisor. And in this regard, I must say that we did not consult with the senior counsel or junior counsel as independent legal opinions. We relied solely on our internal legal opinion. And also, Chair, let me add to the consultation list. We also consulted with SARS in respect of the Arena Holdings case and in respect of what was needed in respect of that amendment. So there was quite extensive consultation with internal stakeholders. Thank you, Chair.
Thank you, DDG Pillay. Look, we're dealing with 6 pieces of information, legislation here. And the relevance of stakeholders changes from one piece of legislation to the other. We have JSC, we've got PAIA, you have PRECA, Child Justice Act and stuff, which requires a whole range of stakeholders. I think we get the fact that you can extend consultation until you submit to the Cabinet, but I think you must take cognizance of that. Minister?
Thank you very much, Chair. I think I note, especially your latter comments about public participation. We'll look at what we will just go back with the team and see what best we can be able to, in cognizance of the issues that you have raised, and with previous colleagues who have raised concerns about it. Chair, and I think the team has addressed quite a number of issues, both in terms of capacity. With the capacity, you'd know that over time our budget has been cut. Yes, there would be prioritization, and I think we've agreed across the board to identify areas where we should be able to build capacity and recruit more, as DG said, but we'll continue to do that. There's still challenges. The issue of review of legislation. I must highlight that from Cabinet point of view, we took a decision that there is a need for us to look at overall all legislation that is pre-1994. The Deputy President wrote to us and indicated that we must be able to flag all those legislation. From our side, in terms of those that we think that are not going to need any changes and need to be repealed, we've decided that we'll do an omnibus. And in terms of our legislative program, we anticipating that will be in the next financial year, if we are to just highlight, Chair. And I have asked also the team to work comprehensively on all those legislation that it's apartheid legislation that needs to be overhauled. I think the team, colleagues here have been raising it, that we need to change some of this legislation so that you don't continue to have legislation that is pre-1994 that is continuing to affect some of the work that we do. So I think later we can come back in terms of those. Honorable members as well raised, I think Honorable Swartz and yourself and Honorable Patron Beck and Honorable Matafa, the whip, raised the issue around just making sure that we pay attention to the time it takes for us to be able to introduce legislation, but more so as well in terms of the deadline, especially with those that are related to the Constitutional Court deadlines where judgments have been issued. We've started as well through OSLA to monitor this, not only for our department, but also for across government, and we are reporting as well to Cabinet as a mechanism. So we did this before, just before Cabinet recess, we presented the report so that even Cabinet at the point and LOGP is able to monitor, because even if we say we're monitoring everybody and we're not monitoring ourselves, so we said Cabinet should be a mechanism that also monitors the compliance in terms of the deadline. But practically as well, Chair, we've been able to pick up that sometimes the court deadlines that are given, in majority of the time, I think, across portfolios, and for various reasons, whether because what they are requesting requires substantive consultation or even amendments for more research to make sure that you are able to look at. We've realized that the 18 months normally given by court is not sufficient because consistently they give us that time. And we've been realizing that majority of the time we have to go back to court to ask for an extension or to condone the delay. And part of why we are saying engagement is necessary with the judiciary to say, perhaps in allocating the time that it requires for us to be able to meet that deadline, for Parliament to meet that deadline, we've got to do a benchmarking. And we said, we'll look at all those and say which ones we've been able to meet in terms of the deadlines that have been given. Because if you had enough time, perhaps you would be together law reform to do substantive inputs like we are doing with Criminal Procedures Act Amendment Bill, which we are expecting to start having it this year. We've gone to the JCPS. They've given us to submit by September. Our deadline was December, but they said at least we must push it to September. So because of extensive work that we have to do, looking at what has been the practice, other court judgments, but the research being assisted by law reform, you do need more time, Chair. And that's why we want to converse with, we are starting this conversation with the judiciary to say in where they are making such comments in terms of suspending a particular piece of clause of legislation, at least sufficient time should be given so that when we pick up that there are substantive measures that we must be able to deal with overall, like you are saying, the JSC Act, we would be able to do that. With a time frame of 18 months, I can tell you with experience and having to do more modern and research around the work, it would not be sufficient to say you can do that, finish and get that legislation approved within that time. Chair, so I hope the issue of the time frame and the issues around almost like what you are plugging, and I do hear what DDG Kale says, but for me as well, in terms of comprehensive, there is a need for comprehensive legislation, but when you have a deadline, it doesn't give you that space to be able to do that comprehensive legislation. Like I said earlier on, the LPC, when I met with, they gave feedback that, yes, we are inputting into what is currently coming, and we've committed to them to say this part of the amendments will come in currently with this process. And then as we work overall in terms of more detailed analysis and also more detailed review, we'll do it later. And I understand the impact because we're doing same legislation maybe twice or three times. And whereas if we had enough time without a court deadline, would just take our time to do comprehensive analysis and do the review of those legislation overhaul and be able to give a proper legislation on all the clauses, having looked at them, or even new clauses that are needing to come through. I think that is from my side in terms of the time frame and also compliance. The team have responded to almost others, that we need to. On the issue Honorable Mhlala raised, I think you did cover it. My matter 21, I don't interfere with Minister of Finance work. So that, as you correctly outlined, Chair, is correct. What we are indicating is that should there be a change in legislation, what you currently have before, not change in legislation, in budget, what you currently have before you as APPs will require us to change. And we are crossing our fingers that there is no reduction in our budget. So far, we don't have a letter. We don't have anything that is indicating. And with the dates that LOGP has provided, we do think that if there's no changes, then it means we'll be able to proceed in that manner. But should there be a need for us to amend, we will definitely consult with you, Chair, how we do that so that we don't create problems for you as portfolio committee, because it's extensive, a lot of work to have to read all these documents for all the people. Perhaps we look at either addendums or even how we do the retabling, but I will consult with you once I know what is happening, and I hope I've answered Honorable Mhlala. Thank you very much, Chair.
Thank you very much, Minister. I think just a few things before we step off this item. The first issue is that when a constitutional court gives a deadline of 24 months, In that 24 months, we have always been saying the work Parliament is supposed to undergo must also be included. So we always denounce the fact that the department comes at the tail end of the expiry of the deadline, constitutional court deadlines. Because the 24 months is supposed to accommodate the fact that the bill is still going to the National Assembly to undergo its process, goes to the NSOP for its process, then goes to the president for assent. So we always stress the fact that when there are deadlines, the department must make sure that they accelerate the work they do in those bills as required by the court and hand over those legislations to Parliament in time so as to allow Parliament to conclude its own process before the actual deadline. We have been able to do that with the RICA. The only challenge was in the presidency, not us. We now have a problem with the Divorce Amendment Act, which is expiring in the next 4-6 weeks as well. So we always stress this matter with the department that it is wrong to only submit legislative amendments to Parliament at the tail end of the Constitutional Court deadline, because it does not accord Parliament sufficient time to deal decisively with the text of the bill. And this thing actually contributes towards the quality of the bills that we enact as Parliament. So you don't get surprised when some of the bills are declared unconstitutional or procedural defect. They have procedural defects. They're supposed to be Section 76 in terms of, or instead of Section 75, because there was no sufficient time for a parliamentary committee to work on these bills. So this does actually erode a qualitative work Parliament is supposed to do on behalf of the people of South Africa. And we'll plead with the department again to ensure that all the bills are submitted to Parliament in time so as to allow Parliament to undergo its process. Before you even arrived, Minister, we have long written to the department to come present or to detail to us the departmental legislative program. We have not received that legislative program until now. And this tampers with the capacity of Parliament to ensure that bills are accelerated within the given time by the courts of law. And on top of that, we've got the Speaker has written to us a letter deferring all the apartheid laws reviews, repeals and stuff to us. And it's a lot of work that the committee needs to do. So if we don't get a comprehensive legislative program from the department in time, we are going to have these problems of deadlines not being met because our legislative program is also congested. And we don't get what we require from the department in time so that we're able to have an inclusive program so that we don't miss this deadline. Yes, of course, Parliament does have a legal right to apply for an extension, but there's no guarantee that the court is going to grant the extension that we apply for. So it's not a good way of working to rely on applications for extensions. There are instances where the court showed us the back door, where we required, I'm sure Honorable Swart and Honorable Bredenbach will agree with me. The last committee has made, I think, 2 or 3 bills where we made an application for the court for extension of the deadline, and we were shown the door. So we must be able to collaborate properly so that we're able to finish this law in time. Because if we do these things haphazardly, we tamper with the quality, we risk having these legislations litigated again and declared unconstitutional again. So let's improve on that, Minister, please. Look, there is no doubt that the issue of the Judicial Service Commission has long been a living proof that capacity is needed for them to expedite the Judicial Conduct Committee issues. I mean, it's a given fact, both in the Magistrate Commission and in the JSC, misconduct matters take longer than expected. So I think an additional capacity is dearly needed there, of course, in both the commissioners and the secretariat, so that we expedite these matters. You know, if one would recall the matter, the latest matter of Judge Hlophe and Judge Mutata, how long they've taken. Of course, it's not only the capacity of the JSC that has contributed, even including legal issues have contributed to the delay, but we're saying an additional capacity would actually help the commission to expedite these matters within a proper time. We have been receiving some complaints from candidate attorneys, but I think maybe if they get a chance, they will come and present their own side of the story when we do public consultations. But they've been raising their frustrations with us against the support we're giving them and against the principles they serve under. But it's matters that we're going to deal with as in when we deal with the text of the legislation. I'm glad, DDG Pillay, that the court has pronounced on the reading in provision. Was in the normal course of events, most of the read-in provisions actually end when the deadline ends. Was the expectation of the court would have been that the period given would actually be a period where that particular legislation would have been completed. And beyond the deadline, there won't be a legislative lacuna. So I'm glad the court specifically pronounced on this, but I think moreover than that, we must be able to work and accelerate the work we do on legislation so that we don't, we would imagine what would happen if the court didn't pronounce on the extended read-in provision beyond the deadline. Look, now we're dealing with a serious problematic issue of RECA members where the reading in provision expired with the Constitutional Court deadline of 34 months. And beyond that, the bill was not ascended by President, and we are dealing with a serious gap in law. So to avoid these things, we must be able to deal with these matters in time. We'll take these matters as well as Parliament on our side for public comments and later public consultation. Then we'll deal with the actual text of the bill, but we'll try and accelerate, of course, without compromising the quality. So, Minister and the team from the department, thank you very much for this presentation. We are now stepping off to the issue.
Chair, just quick one. I'll send you commitment, and I'm apologizing, but I'll send you the list. I wasn't aware that there was a request for legislative program. I'll send it before the end of the week. You'll have it. Thank you. Thank you very much.
Thank you.
And thanks for your understanding.
Thank you very much, Minister. Members, that's all from for this item. Now we're going to take the Constitutional and Legal Services of Parliament for the State Information Bill. Legal opinion. Committee Secretary, who is here on behalf of the Constitutional and Legal Services. Doc, are you representing the Constitutional and Legal Services of Parliament?
Not at all, Chair.
Why are you unmuting your mic?
Only unmuted to respond, Chair.
You are responding to what now? We have lost you.
I was responding to.
We have lost you again, Doc.
No, apologies, Chair.
Chair.
Committee Secretary.
Okay. Maybe let me just start by saying that I have received a letter from. Let me say I received an apology from the minister in the presidency. She's not available due to cabinet commitments, and then we have colleagues from SSA who will be joining us, and also colleagues from legal services who are here to take us through the opinion.
Okay, let's start with SSA. Who is leading the delegation from SSA? SSA. State Security Agency. Who is leading the delegation of SSA? Colleagues.
Chairperson, I'm here as head of the delegation, Bebo Orama Libana, acting manager, legal services.
Yeah, who else is here?
We have Mr. Zoisile Mshungane. We've got Mr. Jabu Khadeve as well, and Mr. Wenyas Bongakonke.
Thank you. Parliament Legal Services.
Good morning, Honorable Chair. Good morning, honorable members and colleagues. My name is Lehoto Moshukwa from Parliamentary Legal Services. I will be presenting the legal opinion.
You came alone.
I'm all by myself, sir.
You are an independent candidate.
Thank you, sir.
Okay, proceed, Mister.
Just waiting for the PowerPoint presentation to be put on screen.
Committee Secretary.
This is a legal opinion on the reservations of the President on the protection of the State Information Bill. These reservations were made in terms of Section 79, subsection 1 of the Constitution of the Republic of South Africa. Slide. As an introduction, our office, which is the Constitutional and Legal Services Office, was requested to advise the committee, the Portfolio Committee on Justice and Constitutional Development, on the reservations expressed by the President of the Republic on the constitutionality of the Protection of State Information Bill, which we would continue to refer to as the bill. So now the background to this matter is as follows. There was a legislative process that was embarked upon prior to the 7th Parliament. On the 8th of March 2010, it dates back to 2010, the Minister of State Security introduced the bill in the National Assembly as a proposed Section 75 bill, whereafter it was referred for consideration and report to the ad hoc committee on the protection of state information bill. Following a second reading, the National Assembly on 16 November 2011 adopted it with amendments. Thereafter, the bill was transmitted to the NCOP for concurrence. The NCOP referred the bill to the Select Committee on Security and Justice for consideration and report. And on 29th November 2012, this NCOP adopted the Select Committee report on the bill, which report recommended further amendments. This recommendation report was in turn referred to the National Assembly. Next slide. Continue with the background. The ad hoc committee considered the Select Committee recommendations over the period of 13 March to 23 April 2013. The recommendations were found to be persuasive and a duly amended version of the bill was tabled in the National Assembly. This amended version of the bill was passed on the 25th of April 2013 and sent to the President for assent. However, on the 12th September 2013, the President referred the bill back to the National Assembly in terms of Section 79, subsection 1 of the Constitution for reconsideration. The reconsideration was as insofar as the sections of the bill, in particular clause 42 and 45, lacked meaning and coherence. And so consequently, as far as those reservations were concerned, those sections were deemed to have been irrational and accordingly unconstitutional. The National Assembly referred the bill back to the ad hoc committee, and the ad hoc committee in turn reconsidered the bill in light of the reservations. This was done from the 9th of October to the 8th of November 2013. The ad hoc committee expressed agreement with the President's reservations, duly amended the bill to reflect several, it was just textual corrections. This further amended version of the bill was passed by the National Assembly on 11 November 2013 and sent to the President for assent. Next slide, please. However, on the 2nd of June 2020, the President again returned the bill to the National Assembly in terms of Section 79(1) of the Constitution. This we would call the 2020 reservations, calling on the House to reconsider the bill in light of the reservations about its constitutionality. This referral being more detailed than the one submitted in 2013. The bill lapsed on the 21st of May last year at the end of the 6th Parliament's term, and after the elections, it was revived on the 25th of July 2024 by the 7th Parliament. Now, the parliamentary rules regulating the Section 79 process is as follows. Joint Rule 235, which was previously Joint Rule 203, states that on receipt of a remitted bill in terms of Section 79 of the Constitution, the Speaker of the National Assembly must refer the bill and the President's reservations to an Assembly committee. And Joint Rule 235 sub 2 sub A further provides that the relevant committee must, subject to sub Rule 3, consider and confine itself to the President's reservations. Can just read out what Rule 235 sub 4 provides, that for specific guidance as to the mandate of the relevant committee. It says that if the committee agrees with the President's reservations, the committee must indicate the steps taken by the committee to correct any procedural defect. B, present with its report an amended bill correcting any constitutional defect in the substance of the bill or resulting from the steps to correct the procedural defect. Next slide, please. C, or make recommendations that any procedural defect can only be corrected by the Council, or recommend that the Assembly rescind its decision to pass the bill and reject the bill if it regards the bill as being procedurally or substantively so defective that it cannot be corrected. Now, the nature of the President's reservations are as follows. In the letter that the President wrote to the Speaker, the President submits that following legal opinions obtained by and public submissions received, the President used the process set out in Section 79 of the Constitution to raise several points of reservations regarding the constitutionality of the bill. Maybe I should pause at this point to highlight the fact that there were two sets of reservations. We call them the first reservations that were attended to, and the second reservations, which are these ones. The first reservations were submitted to the Speaker during the tenure of the former President Zuma, and these ones that are dated the 2nd of June 2020 were submitted to the Speaker during President Ramaphosa's tenure. Now, the nature of the reservations are as follows. Constitutional framework. The first constitutional reservation expressed by the President relates to the restrictions of the rights of freedom of expression and access to information as contained in both Section 16 and 32 of the Constitution. The President's reasons that the bill limits both the sections. The bill limits the freedom of the media and everyone else to access or receive and impart information. He submits that this is a limitation of Section 16. The bill also prohibits people from accessing certain information held by the state, which is a limitation of Section 32. The second set of reservations relates to definitions. The second issue raised in the President's letter is the definitions of national security as well as state security matter, which are broad, and these are not close list definitions and are drafted in an open-ended manner with the use of the word includes. This, according to the President, means that the definitions of national security as well as state security matter are not limited to the definitions provided in the bill. As a result, the definitions leave scope for classifying bodies or officials to interpret the definition of national security and state security matter as they deem fit. The next item is the defenses. The President also indicates that he has reservations regarding the limited defenses provided in the bill in respect of the offenses as set out in Chapter 11, that is clauses 34 to 48 of the bill. Next slide. Two defenses relate to public interest defense, which is the first one. The President expressed reservations about a lack of public interest defense to offenses relating to unlawful disclosure and possession of classified information as contemplated in clause 41 of the bill. According to the President, this will create an unjustifiable chilling effect on the freedom of expression. The second defense is the public domain defense. The President also raised his reservations that the bill in its current form does not afford anyone in possession of classified information an opportunity to rely on the public domain defense. The President asserts that it is a basic principle of privacy law that once information loses its secrecy by virtue of it being in the public domain, for example, such information can no longer be protected. The third reservations relate to classification and declassification. In the context of classification and declassification, the President had the following concerns. The President expressed reservations concerning the classification of state information as it pertains to clause 12, subclause 2 of the bill, which provides that a head of an organ of state may delegate in writing the authority to classify state information to a staff member at a sufficiently senior level. The President expressed concern that sufficiently senior is an undefined term, and it is unclear who can designate staff and how such designation is determined. The clauses pertaining to classification of state information are impermissibly vague, unconstitutional, as they unjustifiably limit the right to freedom of expression and access to information. Next slide. With regards to declassification, the President raised concerns that the bill makes no provision to sever information which should legitimately remain classified following a request for access to classified information. Consequently, an entire document could be withheld despite information in that document having no bearing on national security. The President expressed concern that the lack of such severability provision is an unjustifiable limitation on the rights of freedom of expression and access to information. With regards to classification of the bill relating to tagging, the President raised concerns regarding the tagging of the bill with regards to the following impact on provisional interest. The President is of the view that the bill provincial organs of state, because Section 239 of the Constitution includes provisional entities as organs of state. Accordingly, reference made to organs of state within the context of clauses 3.3 and 5 sub 1 can be read as affecting provinces. The President further contends that clause 6, read with clause 7 sub 1 and 51, prescribes how valuable information, the state information, must be dealt with at the provincial level. It is argued that this will have an impact on the management and control of provincial archives. Archives other than national archives is a functional area of exclusive provincial competence as set out in Schedule 5 of the Constitution. The President therefore argues that the bill affects provinces and should be classified as a Section 76 bill. Next slide. Now, this is the legal analysis of all the reservations that were expressed by the President. Whether clause 35 of the bill infringes upon the Section 16 of the Constitution must be determined by reconciling it with Section 16 and with due consideration to the limitation test as set out in Section 36 of the Constitution, which is the limitation clause. Clause 35 of the bill sets out the criteria and processes in terms of which state information may be protected from unauthorized and unlawful disclosure. Clause 35 of the bill basically provides for periods of imprisonment upon conviction divided into 3, that's 25, a period not exceeding 25, 15, and not exceeding 5 years. It says it is an offense punishable on conviction by imprisonment for a period not exceeding 25 years to unlawfully and intentionally receive state information classified top secret, which the person knows would directly or indirectly benefit a foreign state to the detriment of the national security of the Republic. 2 says it is an offense punishable on conviction by imprisonment for a period not exceeding 15 years to unlawfully and intentionally receive state information classified secret, which the person knows would directly or indirectly benefit a foreign state to the detriment of the national security of the Republic. Clause 35(3) says it is an offense punishable on conviction by imprisonment of a period not exceeding 5 years to unlawfully and intentionally receive state information classified confidential, which the person knows would directly and indirectly benefit a foreign state to the detriment of the national security of the Republic. In clause 1 of the bill, national security is broadly defined as including the protection of the people of the Republic and the territorial integrity of the public against, inter alia, the threat of use of force or use of force, hostile acts of foreign intervention directed at undermining the constitutional order of the Republic, terrorism or terrorist-related activities, espionage, exposure of a state security matter with the intention of undermining the constitutional order, exposure of economic, scientific, or technological secrets vital to the Republic, sabotage, serious violence directed at overthrowing the constitutional order of the Republic, and act directed at undermining capacity of the Republic to respond to the use of force and carrying out the Republic's responsibilities to any foreign country and international organization. Freedom of expression includes the protection of freedom of the media and press, and the freedom to receive and impart information. Our courts have emphasized the importance of freedom of expression as an integral part of our constitutional order. In Kumalo and others versus Holomisa, the Constitutional Court acknowledged the role of the media in a democratic society and held that the print, broadcast, and electronic media have a particular role in the protection of freedom of expression in our society. Okay. Therefore, Section 16 of the Constitution must be interpreted against this background. It must be noted that Section 16(2) serves as a limitation of the right to freedom of expression, which provides that certain expressions like propaganda for war, incitement of violence, or advocating hatred are not protected in terms of Section 16. In Lafitte of Promotions, CC versus South African Breweries International, the Constitutional Court emphasized that Section 16 contains two parts. The first subsection sets out expression which is protected under the Constitution, i.e. freedom of press and other media, receiving information or ideas, artistic creativity, and academic and scientific research. The second subsection contains three categories of expression which are expressly excluded from the constitutional protection. And therefore, the court concluded that unless the expressive act is excluded by Section 16(2) of the Constitution, it is protected. In summary, freedom of expression encompasses any form of human expression. The effect of the constitutional recognition of the right to freedom of expression is that the right has a fixed meaning and content, in that limitation to the right must comply with the provisions laid down in the Constitution. The content of the right may only be limited by the internal limitation listed in Section 16(2) of the Constitution, and if justifiable, the requirements laid down in Section 36, namely the limitation clause. The scope of the right, which is the right to access to information. The right of access to information is enshrined in Section 32 of the Constitution, and it's a vital component of a free, open, democratic society. Section 32(1) of the Constitution guarantees the right to access information that is required for the exercise or protection of any rights. To give effect to this constitutional provision, Parliament promulgated the Promotion of Access to Information Act of 2000 by year. Section 9B of BAIA stipulates that the object of the Act is to give effect to the constitutional right of access to information subject to justifiable limitations, including but not limited to limitations aimed at the reasonable protection of privacy, commercial confidentiality, and effective, efficient, and good governance, and in a manner which balances that right with any other right in the Bill of Rights contained in the Constitution. Next slide. The court in Brumer versus Minister of Social Development and others stated that access to information is crucial to the right to freedom of expression, which includes freedom of the press and other media and freedom to receive and impart information or ideas. As discussed, subsection 16(2) of the Constitution sets an internal limit beyond the right to freedom of expression enshrined in Section 1 does not extend. The connection between Sections 16 and 32 is demonstrated by the Brumer judgment. In order to pass the test of constitutionality, the bill must not only be a law of general application, but must also show that any limitation to a right, and in this case, the right to freedom of expression, particularly including the freedom of the press and other media and freedom to receive and impart information or ideas, is reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom, taking into account all the relevant factors, including the nature of the right, the importance of the purpose of the limitation, the nature and extent of the limitation, the relationship between the limitation and its purpose, and the less restrictive means to achieve that purpose. Next slide. The court in Bruma stated that each of these factors must be weighed up, but ultimately the exercise is one of proportionality, which involves the assessment of competing interests. Where justification rests on factual or policy consideration, the party contending for justification must put such material before the court. The court further stated that the importance of the right to access to information too in a country which is founded on values of accountability, responsiveness, and openness cannot be disputed, and to give effect to these founding values, the public must have access to information held by the state. It is clear that through the legislative process of the bill, there have been a number of changes following various submissions and legal input and advice at the time. In particular, the definition for national security has been extended, and a quasi-public interest defense, that is clause 41 of the bill, has been included in response to such legal concerns which were raised. However, the provisions of the bill would still render it illegal to possess such classified information unless the possessor of such information raises a defense envisaged in clause 41. This creates an onerous burden and will require journalists to use time and money to defend themselves. This will have the effect of stifling media freedom. Therefore, criminal activity is not clearly prescribed in clause 41 of the bill, which renders the provision vague. Slide. Although clause 35 of the bill contains a proviso that the top secret information received should directly or indirectly benefit a foreign state to the detriment of national security of the republic, the actual determination of what is top secret is entirely dependent on a functionary or an official of the state, with no objective party or tribunal prescribing classification. This could result in inconsistency. It holds true that state security is an important purpose, weighed against the role of the media, which is an instrumental function of our democracy. However, in considering the relationship between the limitation and its purpose, whether there is good reason for the law to infringe upon the right in the way it does, it is doubtful whether the purpose outweighs the importance of the protection of the right. Lastly, in considering the efficacy of the bill and whether the object could reasonably be achieved using an alternative or less restrictive means, it is argued that perhaps the Promotion of Access to Information Act of 2000 could be used to effect further limitation to access information that is confidential or otherwise required to be protected. In conclusion, we are of the view that the bill unreasonably infringes upon the rights enshrined in Section 16 and 32 of the Constitution. With regards to the definitions, regarding the reservation raised regarding the broad definitions of national security as well as state security matter, the President refers to the case of Dawood and another versus Minister of Home Affairs, which would further refer to as the Dawood case. The court in Dawood cautioned Parliament against conferring a broad discretion upon an official who may be untrained in law and constitutional interpretation, and expecting that official, in the absence of direct guidance, to exercise the discretion in a manner consistent with the provisions of the Bill of Rights. The court stated that the legislature must take care to limit the risk of an unconstitutional exercise of the discretionary powers it confers to officials, as it has a constitutional obligation to respect, promote, protect, and fulfill the rights in the Bill of Rights. Caution must be applied when using the word includes in a definition. The purpose of a definition is to provide clear parameters. According to Professor Tantaki, Includes, the word includes means the legislature intends to keep the door slightly ajar lest something has been omitted through an oversight. Dr. Twantaki states that a provision in a definition in a law containing an extended meaning, a part of the conventional meaning by using includes, may at worst induce an unintended interpretation of the meaning. Generally, in light of the Dawu decision, includes should not be used unless an open-ended definition is expressly required and justified in the circumstances. The current bill does not present such a justifiable context, as the bill in design limits rights and limitations should be approached with extreme caution. Avoiding an unqualified includes in definitions ensures that there is no room for interpretation that could unintentionally grant a decision maker an unfettered discretion in the determination of the scope of the application of legislation. In other words, a clear policy must underpin the definitions used to limit rights in the Bill of Rights in a manner that ensures certainty. The bill appears to fall short in this regard. Furthermore, the President is concerned that even though Clause 8 sets out the conditions for classification, the provisions are still overly broad in scope, and that's insufficient to save the bill from unconstitutionality. The President refers to the case of Case and Another versus Minister of Safety and Security and others, which concerned a challenge to the constitutionality of Section 2 sub 1 of the Indecent and Obscene Photographic Matter Act of 1967. The court held that the impugned section constituted an infringement on the right to personal privacy guaranteed in terms of the interim constitution then. The court held that the invasion of the right to privacy was aggravated by the very broad definition of indecent and or obscene photographic matter contained in the act. In this instance, the definitions of national security and state security matter are broad, as they are not a close list and as such are prone to be interpreted differently by different administrators or officials. In light of the above discussion, our office is in agreement with the President as to the definitions of national security and state security matter, namely that they are too broad and create a risk of abuse. Definitions should promote certainty, and such must be underpinned by clear policy to ensure that the affected constitutional rights are not unduly and unreasonably limited. If the committee agrees with this view, it is advised that the department be consulted as to the policy implications that could result from an amendment to the affected definitions. It would be advisable for the committee to request the department to present a proposed amended text that would address the concern raised with regards to the overly broad scope of the definitions in question. With regards to defenses, the President states that clauses 34 to 48 of the bill sets out the offenses and related penalties for non-compliance with the provisions of the bill. In 10, clause 41 of the bill provides 3 narrow defenses limited to the offense of disclosure or possession of classified information. Accordingly, the President is concerned that the defenses provided in clause 41 of the bill are narrow and do not take into account other defenses that are widely recognized in our jurisprudence. For example, the public interest and public domain defenses. The President is concerned that while the bill does provide for the 3 narrow defenses, it omits to provide the offenses. With regards to the public interest defense, the limited defense in clause 41 will not withstand constitutional scrutiny. According to the President, the defenses provided in clause 41 are narrow and only provided in respect of disclosure and possession of classified state information. No defenses are provided for certain other offenses. This may create a situation that would allow the arbitrary and thus irrational limitation of the right of freedom of expression, and this will be contrary to public interest. To address the concern, the bill could provide for a public interest defense. The introduction of the public interest defense would not be new. It has been introduced in the secrecy laws in other jurisdictions. It has now been recognized in common law where it functions as a defense to an infringement of privacy. The Constitutional Court in Independent Newspapers versus Minister of Intelligence Services has recognized the importance of public interest in the context of security cases. And it held as follows. It said, on the other hand, the circumstances in which an intelligence agency came to improperly and unlawfully infringe upon the privacy of an innocent citizen are not merely matters of public curiosity. They would be issues of immense public interest. The degree of public interest is an important factor to be put into the balance and would, in my view, not be of insignificant weight if the interest is one that must be fulfilled. The starting point of the inquiry into whether the document should be released is that it was of great public importance and justified considerable public interest. Furthermore, the President is concerned that the bill does not provide for a public domain defense that is unjustified and that unjustifiably limits the right to freedom of expression and access to information. We agree with this concern. It is tried that once information loses its secrecy, for example, by falling into the public domain, for whatever reason, such information can no longer be protected. Slide. Providing for a public domain defense will align the bill with the recognized principle of confidentiality, which states that it is futile to protect information that has lost its secrecy. This principle has been recognized in a number of legislation and courts. In independent newspapers, the case that we mentioned above, the Constitutional Court further held that if the information is already lawfully in the public domain, there can be no reason for its non-disclosure. With regards to classification and declassification, the President also indicated his reservations concerning Clause 12 of the bill, which provides that any head of an organ of state may classify state information. In addition, the head of an organ of state may delegate in writing the authority to classify state information to staff members at a sufficiently senior level. The President is concerned that sufficiently senior is an undefined term, and it is not clear who can designate and to which category of staff members and how such designation is determined. The President submits that this opens the bill to a constitutional challenge for being impermissibly vague and in violation of the constitutional principle of legality. Next slide. The principle of legality requires that the executive and all organs of state may exercise no power or perform no functions beyond that conferred to them upon them by the law. It is a requirement of the rule of law that the exercise of power by the executive and other functionaries should not be arbitrary. Decisions must be rationally related to the purpose for which power is given. Otherwise, they are in effect arbitrary and inconsistent with this requirement. As such, the President's reservation is valid. The failure to clearly define the term sufficiently senior, inclusive of the parameters as to the staff in question, in the bill creates ambiguity with regards to who has the power or authority to designate a staff member and how such designation is determined. Such ambiguity infringes on the principle of legality. The President is also concerned that there is no confinement to the authority granted by Clause 12(6) of the bill. The exception granted in respect of South African Police Services and the South African National Defence Force members further extends the authority to an unidentified group of people. This creates further ambiguity, as this clause is not clear, resulting in the provision also falling short of what is required by the principle of legality. As part of the reservations in this regard, the President also reasons that the word must in Clause 12 may result in overclassification because of the duty imposed and should be replaced with the word may to render it an empowering provision. We submit that there is no harm in replacing the word must with may in the context. It is clear that the provision in question is one that confers power or authority. Thus, the use of may in such an empowering fashion would be appropriate in the circumstances. The President contends that although Chapter 6 provides for review and appeal processes, no provision is made for severance of legitimately classified information. This creates a situation where an entire document can be withheld, even if it contains information that has no bearing on the state security. The lack of severability is an unjustified limitation to the rights and access to information, in that it unduly limits the public from accessing information that would have ordinarily been available to it had it not been contained in a classified document. Our jurisprudence recognizes the principle of severability in relation to information disclosure. For example, Section 28, subsection 1 of PAIA states that if a request for access is made to a record of a body containing information which may or must be refused in terms of any provision of Chapter 4 of this part, every part of the record which does not contain and can reasonably be severed from any part that contains any such information must, despite any other provision, be disclosed. Slide, please. The bill does not make provision for the severance of the classified information in the case where both classified and unclassified information is contained in one document. The lack of severability is an unjustifiable limitation to the rights of freedom of expression and access to information. Clause 17.5 of the bill requires the head of an organ of state to consider the conditions for classification and declassification in clauses 8 and 11. According to the President, these conditions are inadequate to qualify as sufficient guidance, taking the Dawood judgment into account, as clause 17.5 requires the head of an organ of state to determine that the public interest in disclosing the information clearly outweighs the harm that will arise from the disclosure. The legislature has an obligation to identify the policy consideration that would inform the decision as to when the public interest outweighs the harm that will arise when disclosing information. Although it is the executive who is responsible for formulating and implementing policy, the legislature must take care to limit the risk of an unconstitutional conferral of discretionary powers in the fulfillment of its constitutional obligation to respect, promote, protect, and fulfill the rights in the Bill of Rights. With regards to the tagging of the bill as a Section 75 bill, the President is of the view that the bill does affect provinces because Section 239 of the Constitution includes provincial entities as organs of state. As the bill refers to all organs of state, it therefore affects provinces. Clause 3.3 of the bill provides that the bill applies to all organs of state. Lastly, clause 5.1 obliges the head of an organ of state to establish conditions for the protection against alteration, destruction, loss of state information. The President further contends that clause 6, read with clause 7.1 and 51, prescribe how valuable information and state information must be dealt with at the provincial level. This will have an impact on the management and control of provincial archives. Archives other than national archives is a functional area of exclusive provincial competence as set out in Schedule 5 of the Constitution. The President argues that this bill should have been tagged as a Section 76 bill. Section 44.2 of the Constitution, which provides that Parliament may intervene by passing legislation in accordance with Section 76.1 with regards to the matter falling within a functional area listed in Schedule 5 when it is necessary. Next slide. To maintain national security, to maintain economic unity, to maintain essential national standards, to establish minimum standards required for the rendering of services, or to prevent unreasonable action taken by a province which is prejudicial to the interest of another province or the country as a whole. The test for tagging is informed by the purpose of the bill. The more it affects the interest, concerns, and capacities of the province, the more say the provinces should have on its contents. The object of the bill are inter alia to regulate the manner in which state information may be protected and to promote transparency and accountability in governance while recognizing that state information may be protected from disclosure in order to safeguard the national security of the Republic. In the process of tagging, the provisions of the bill, in substantial measure, were found not to relate to functional areas listed in Schedules 4 and 5. As indicated above, the bill was tagged as an ordinary bill not affecting provinces, as the provisions of the bill viewed in light of its express object do not give effect to any grounds listed in Section 44(2). Should the bill be reconsidered by the National Assembly and the NCOP in respect of tagging, Parliament would have to justify the classification of the bill with reference to Section 44(2) and include the same in the objects of the bill. When the bill was deliberated upon at different stages in the previous stages, the Office of the State Law Advisors provided legal advice and support to the committee. Our office was not required to provide any input or advice. In conclusion, in terms of Joint Rule 235, it falls within the mandate of the committee to decide how it wishes to proceed with the bill. As set out in the above discussion, our office holds the view that there is merit in most of the President's reservations, as these address crucial issues of ambiguity which could result in the abuse of power, unreasonable infringement of rights, and application that could undermine the principle of legality. Our only point of disagreement in its current form is on the issue of tagging. We are of the opinion that the bill was correctly tagged. But in the event that further amendments are made in addressing the President's concern, this could result in a change in tagging. The committee may engage with the joint tagging mechanism at the appropriate point in the process. As discussed above, the President's reservations relate to several policy considerations that are substantive and which will require the committee to closely work with the department in obtaining clarity of such purposes and deliberations on the Section 75 reservations. If the committee regards the President's reservations as persuasive, inputs from relevant department would be required to obtain guidance on possible rephrasing or expansion of affected provisions in line with the relevant policy considerations. And that brings me to the end of the legal opinion. And thank you very much, Honorable Chair.
Thank you very much, So that indeed is a very elaborate reservations from the President, very elaborate and specific on issues. Members, before we come to you, can we check if SSA has anything to add? SSA, anything to add before members deliberate?
Thanks, Chair. We note the comprehensive legal advice. Will rely on your guidance.
You will what?
Will rely on your guidance on the way forward.
Okay, thank you. Thank you, SSA. Members, let's go. Yeah, now we'll have Honorable Nomvalo, Honorable Swart, Honorable Breitenbach, Honorable Matafa. Honorable Nomvalo, could proceed.
Yeah, thank you very much, Chair. On our side, Chair, we're not going to engage on the substance. Two, I think the presentation has been comprehensive and vivid, so there is no confusion. There is no clarity seeking question. So we are just going to engage further when we get into the deliberations. For now, what I just wanted to raise, Chair, is that I think it's not for the first time that we get an apology. If there was an apology, by the way, because there has been no indication that there is an apology, but what we've been told is that the minister in the presidency is not part of the meeting. So I just wanted to raise that issue to say it's not for the first time. And we're noting that every time we sit these kind of meetings, which whose relevancy touch on the presidency, because here we're engaging on the reservations which were addressed by the presidency, and the bill was referred to us to Parliament by the president. So we don't find it justifiable that we can sit these kinds of meetings with apologies, if there are apologies, or with a continued absence of the office of the president. I just wanted to raise that, Chair. There is no further issue that I want to engage. I think we will thoroughly engage on their substance when we deliberate on the bill. Thank you very much.
Thank you very much, Madam Nomvalo. Of course, the office of the president is very crucial for the purposes of this meeting. That point is actually noted, very important. Honorable Swart. Honorable Swart.
Thank you, Chair. My apologies. I was just trying to unmute. Chair, there's a lot to consider here, and if you allow me to give a bit of background, I was involved in the previous process, and it's very important to note that the previous process was dealt with by an ad hoc committee and not by the Justice Committee, number one. Secondly, that the Parliamentary Legal Office was not included. I can't remember what the reason was, but sadly they were not included in that process, and had they been included, we might have been in a different situation today. It's very important also to note that ourselves, that's the ACDP, the DA and the IFP, argued against the bill right from the word go and raised all these issues that have been raised in this legal opinion and the President's reservations during the deliberations. And I must say that even members of the majority party, the ANC, raised concerns, and the bill was improved. It was improved. Even the quasi-public interest defense of Section 41 that was inserted was as a result of pressure from Parliament across the board. Chair, it was myself and the late Dean Smuts that jointly drafted the petition to President Zuma raising all these issues. Subsequently, and I think it's important to note why was there such opposition to what was then known as the secrecy bill? It was that political parties, that's including across the board, civil society, and even members in the majority party, the ANC, were concerned that state departments would use the provisions of the bill to conceal corrupt or illegal activities under the guise of classification. Now, it was improved, and we sit in with the legal opinion, the reservations. I think it's a bill that nobody really wanted to touch once it had been referred to the president, and it took 7 years. 7 years. It was sent back to the president for assent on the 11th of November 2013. 7 years later, 2nd of June 2020, President Ramaphosa sent it back to Parliament with these reservations, which again, I emphasize, every one of them, or almost everyone, was raised by various political parties in our deliberations and now have been confirmed by the legal opinion. So I think, Chair, I think the key aspects here, without going into A lot of the detail is, of course, the public interest defense, the public domain defense, the broad definitions of national security and state security matters, and the tagging of the bill. And we welcome the opinion that finds that at the end of the day, the bill is unconstitutional for various reasons, as raised by the president, breaches Section 16, has a chilling effect on journalists, on whistleblowers, on any other person that has classified information which discloses offenses and is in breach of Section 32. So, Chair, I wanted to just give that bit of background. And from our perspective, we look forward to a process going forward involving our parliamentary legal advisors, involving the Department, State Security, and of course, Justice, where we can find a bill that weighs up the needs for national security with the access to information. And obviously, PIA plays a very important part, and the provisions in PIA as well. So, Chair, thank you for allowing me those few opening comments on the basis, but the history of this whole matter is set out in parliamentary documentation going over a number of years. Thank you so much.
Thank you very much, Honorable Swart. Honorable Brettenbach.
Thanks, Chair. Yeah, I am covered by the Honorable Swart. All I can say is we argued these points. We were ignored. The bill was dealt with in a shocking fashion, quite frankly. And I agree with the legal opinion, and this whole thing needs to be revisited. Thank you.
Honorable Matafa.
Thank you, Chair. Thanks for the presentation on the legal opinion. Chair, my starting point would be from where Honorable Nombalo left off in terms of the apology from the Minister in the Presidency, because I would wish either to make a proposal or ask a question in terms of the procedure going forward. And also link my input to what Honorable Swart raised about the ad hoc committee, because in the beginning of the legal opinion, they do state that the matter was being attended through an ad hoc committee. So my first question would have been, if whether is it proper to continue with the platform being the Committee on Justice, or should we consider resuscitating the ad hoc committee to deal with the issue? The timeline that Honorable Swart speaks to, I mean, if this bill was initiated in 2010 and now we're in 2025, it's almost 3 parliaments that could not finalize it. And if you consider the context given in the legal opinion, there was a lot of toing and froing between the parliament and the office of the president. So my question or suggestion would be, would it not be proper, one, to re-establish the ad hoc committee, as the reservations are the only area on which we are confining ourselves? But secondly, maybe the ad hoc committee be mandated to engage with the legal team that is advising the president, if it is possible. So the presence of the minister in the presidency would have assisted on the process related to that, or the possibility thereof, so that in the event we do relook and rework the bill, there should not be a situation that we find ourselves again here with amendments proposed by the National Assembly, concurred to by the NCOP, and then come back not to have met the understanding of the legal team and the president. And then we end up in a vicious cycle, which does not end. My last point, I think that process, Chair, will assist on the issue of also clarifying the tagging mechanism that should be pursued. And then I think that will also clear up any issue of concerns around interpretation, rationality, or phrasing of this particular amendments in addressing the stated reservations. A question to the legal opinion as it was presented. In the conclusion, it says there is merit in most of the present reservation. And then further goes on to say, our only point of disagreement is on the tagging. So if you say most and you say only, can we then say it should read that all the present reservations have merit except the one on tagging? Because if the way I read it and interpret it, if you say most, it means that there are some that might not have merit, but yet they are not listed. So if my understanding can just be clarified, does it mean that all of them are okay and they have merit? It's only on the tagging, or there are some that have got no merit and they should also be considered going forward? Thank you very much, Chair. I will pause there.
Thank you. Legal Services, please attend to just the issue, the last issue Honorable Matafa has raised of only the tagging mechanisms you disagree with the reservations, otherwise everything else you agree with.
Thank you, Honorable Chair. I confirm that Honorable Matafa's interpretation is correct. The phrasing is regretted. The meaning should be all have merit except the tagging issue. So all the presidential reservations have merit, as we have discussed them in the legal opinion and agreed with them, except the issue relating to tagging. Thank you.
Thank you very much, members. Thank you very much to the Parliamentary Legal Services Unit. And
my hand is up.
yes, Honorable Mhlala, I didn't see your hand.
Oh, okay. No, thanks so much, Chair. No, Chairperson, I just want to say that we take note of the Protection of State Information Bill, and we acknowledge the importance of engaging with it critically and constructively. So we will go as well and check where we can find the loopholes. If we concur with the bill, we will, during the deliberation, we will come back with a thorough researched work of whether we agree or we don't agree with that. But our concern, Chairperson, is the concern of the fact that the bill went back and forth for about 15 years. I think this thing must not repeat itself again, because where there is a lack of legal perspective on certain issues, it will create a problem for our country. So I think going forward, this thing of going back and forth will come to the end. We understand that it goes back and forth because we want to come out with a proper document, but not on what we saw here, where a bill is passed by Parliament, maybe and then the president respond after 5 years. It doesn't make sense at all. It shows that we have a problem with the office of the presidency. And I also would like also to support the speakers that spoke about the Minister of Presidency, who always not attending our meetings, because we were supposed to raise these issues of what we are concerned of to her, and she's not here today to answer for the office of the president. So that is the concern. I think most of us in the community have raised it, and we are really concerned about it. Thanks so much, Chairperson. I think the legal office have done a very important work, and they've narrated everything as it's supposed to be done. We will go and study the document properly. When we come back to deliberate, I think we'll be able to deliberate fruitfully. Thank you so much.
Thank you very much, Honorable Mhlala. Members, I think we all are in agreement that it is quite unprecedented that a bill can take this long and it can enter and exit Parliament, enter and exit the presidency for numerous times. I think it's not an ideal situation that all of us would envisage. It tells that there might be some deep-seated issues that we need to take deep consideration of when considering the matters relating to this bill. Of course, on Matafa, I heard what you are saying clearly from the presentation that the Legal Services Office actually is saying, we agree with the president in everything that he has raised, except only the tagging mechanism, whether it's a Section 75 or Section 76 bill, which they only have a different submission from that of the president's only in that regard. So I think it's a very strenuous situation that all of us would agree that it's not an ideal situation. And thanks, Honorable Swart. I think the background you have presented here actually is one of the things where some of us have seen on TV. It was one of the most discussed bills on current affairs in the country. And it was way before myself and Honorable Matafa even came to Parliament. Never have we thought that we'll come to Parliament and this bill will still be in discussion in parliamentary committees. So it tells you that there are quite a number of issues that the president is raising, including security-related matters, including constitutionality of the bill, including ambiguity and vagueness. And part of what the presentation does is to reveal what the State Information Bill says and compare with what PAIA actually provides. So I think members, when we deliberate again, this is what we're going to do. We are going to call for a last meeting of this nature to decide on what must happen to this bill. The last meeting will be a committee meeting. The Department of Justice will be in attendance. The presidency, through the minister and the president and their legal team, are going to be in attendance. SSA is going to be attendance. These are three questions that that meeting needs to answer. One, should we start the bill afresh, as Honorable Breitenbach is suggesting, revisit, start and rework the bill in accordance to what has been raised by the president? The second issue for consideration is that are we detaching the committee from working on this bill and make a recommendation to the House that the House must establish an ad hoc committee to deal with matters relating to this bill, because it looks like it has issues that are cutting across a number of disciplines. Lastly, should we not consider the bill having been exhausted and uncurable and irreparable, and such that we should just make a recommendation to the House to just rescind the bill and discontinue this bill, given what PAIA provides in text, and we've seen in our courts daily individuals, organizations, stakeholders making PAIA applications to court. regarding a number of issues. I think there's a recent one that was done by Action SA, which is still pending. So maybe it covers parts of what the State Information Bill wanted to address, but it's a matter that we'll answer as the committee in the next and the last meeting regarding this bill to determine on what must happen, what is the future of this bill, because what we're seeing is actually not desirable for the work of Parliament and both the presidency, actually all the arms of state. It's not desirable to work in this manner. It would be acceptable for Parliament to enact a bill, sends to the president for assent, and the president does reservations, the Parliament reworks the bill, and then it's passed. This back and forth is actually problematic for the work of the entire public service and the people of South Africa. So we're going to look for a day to actually attend to this and determine the future of this bill. Having said that, colleagues from SSA, thank you for continuously attending our meetings when we require you to on issues that may affect your operations and work. It's very important that you actually are in attendance to Parliament to understand the steps that we're taking towards legislative frameworks that may affect your work. We're still, juggling with issues of RICA with the president. Parliamentary Legal Services, you have outdone yourself. Your presentation was unambiguous. It's only the president that says the State Information Bill is ambiguous. But Tina, as the committee was saying, your presentation to the committee around the reservations of the president was unambiguous. So it was elaborate, comprehensive, and straight to the point, and made the committee to understand the cons and pros of this bill. So we thank you very much. You are now released. Members, can we remain for 3 minutes to do some housekeeping issues? SSA Legal Services Unit, you are released. Mhlala, can you mute your mic? SSA Legal Services are excused.
Thank you, Honorable Chair.
Thanks.
Members, can we remain for 2 minutes to just do some few housekeeping issues? Committee Secretary, have they left all of them?
No, not yet, Chair. They are leaving.
Let's wait for them to exit. Please confirm on the